So, Asha, will the Trump administration be held accountable for committing war crimes?
It's complicated.
I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rengappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm the author of the Freedom Academy Substack.
I'm Ryan Goodman. I'm a professor of law at NYU, where I also teach national security law. I'm co-editor-in-chief of Just Security and a former special counsel at the Department of Defense.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet.
Thank you, Ryan, for being here. So I think our listeners have not had the pleasure of hearing Ryan. Shockingly, we have not had him on the podcast, but Ryan is an expert in all things war crimes. And I know that Just Security has been really on top of this boat strike issue from the beginning in terms of getting, expert analysis and, understanding what is happening and the legality of it. And also, what we still know and what we don't know. So do you want to give us a recap for people? We have done a pod before on why these are illegal, but maybe we can just do a recap of kind of what the Trump administration is claiming and why they are kind of doing a legal sleight of hand in terms of their legal argument for the use of war powers here.
Great. So thanks so much for having me on, and really looking forward to the conversation. I really appreciate your teeing it up that way, because I do think one of the most fundamental questions is what legal body of rules actually even apply to the boat strikes, because that's the sleight of hand that from the 3,000 foot level, the Trump administration is trying to put all of these military operations of lethal strikes against suspected drug boats in the Caribbean and East Pacific into the box of the laws of war, saying this is an armed conflict. Because if they can get it into that box, then generally speaking, the rules under international law and domestic law are much more permissive. They allow for much greater uses of lethal force than the box that it really belongs. And I think you can ask basically almost any law of war expert, which would say this is not an armed conflict as that is defined by the Geneva Conventions and very settled international humanitarian law. It is law enforcement. It's a peacetime operation, and it is not that permissive set of rules. So I think that's, first order kind of question, even to the point that folks like me have a lot of ambivalence in even describing the September 2nd double tap strike, which we'll get into, as a war crime, because to be a war crime, it has to be in an armed conflict, and the laws of war have to apply, and they really don't. And now, if it were an armed conflict, so giving the Trump administration that argument, we're in the realm of a war crime. But because I mentioned it is a more permissive rule set, the law enforcement rule set would obviously, a fortiori, even more so, determine that what has happened on September 2nd would be an international crime, and an extrajudicial killing would be the term for it.
This is such a, Brian, this is such a departure from the way in which we ordinarily deal with narcotics trafficking. And, people have tried to offer parallels to other strikes in U.S. history that were, let's say, people trot out, I think people and MAGA, Trump out, trot out, Obama, had drone strikes. Can you help and just set some context about how different this is than the way that the United States has ever acted in the past in its history?
Yeah. And I also think it's interesting that critique comes from the left as well. The idea, we published a piece by Brett Max Kaufman, whose argument was, not one that I agree with, but we published views that I do not agree with, often, which said, this is all of a piece in a certain sense. Or the groundwork was all laid by the Obama administration and the George W. Bush administration after 9/11, that the global war on terrorism had already stretched the boundaries so far, and there was the entirety of drone warfare from that perspective, from the critique perspective on the left, and that was all an extrajudicial killing on its own terms. So this is just one click over. And then MAGA folks, I think, saying the same thing in a certain sense, like, wait, this is nothing different. And when Obama, for example, was bombing the al-Shabaab group in Somalia, well, guess what? Drug cartels kill far more Americans than al-Shabaab in Somalia ever did or ever could. So that's the background argument. Now, my view on that is, and that one's more contested and it's complicated, is no, this is, I accepted the George W. Bush, Obama, Trump, Biden, Trump view that post 9/11 was an armed conflict in which lethal force could be used against members of the terrorist organizations that had attacked the United States on 9/11 or had associated with them in a co-belligerent status. That was an armed conflict because one way of thinking of it is the strikes that took place on September 11th. If any state had done that, we would be in a war. Everybody would agree, but it was a non-state actor that did it, an organized armed group that did it, and that's what a non-international armed conflict is: a conflict between a state, non-state actor, organized armed group in which the level of violence is at a severe enough echelon and is protracted over time. And so there you have it. And especially after the US invasion in Afghanistan, we were off to the races on consensus view that we're in an armed conflict. And therefore the permissive rule set applies of use of lethal force. I find myself in the company of John Yoo, one of the architects of the George W. Bush Office of Legal Counsel post 9/11 framework for dealing with 9/11, in which John Yoo has said, writing an op-ed in the Washington Post, what the Trump administration is trying to do is nothing like that. There's no way in which it's conceivable that the law of armed conflict would apply to drug cartels. There's been very few, but like one article I've seen where somebody has tried to defend it, somebody with a law degree. And their entire argument, I would give like a B- if it were an exam, because they can't get to the point of ever showing any military violence on the part of these groups. Instead, they try to convert drugs and people dying by drugs as though that is the test for military violence. And it just obviously isn't. It never has been. It's always been treated as criminal activity, law enforcement. The United Nations would never on this planet agree with the idea that that is what is an armed attack. So that's basically why I think this is just so far afield of any of that.
Well, Ryan, you're talking about the law of armed conflict, which is international law, but also one of the things that you mentioned in the looking at the parallel of 9/11 is that Congress authorized the use of military force in that situation. And I think that people do not understand the significance of that and how that triggers war powers for the commander-in-chief. That the 2001 AUMF is an expression of Congress's declare war power, that they set under the AUMF the parameters under which he can use them. Because I think the other conflation that's being made here that people sometimes I think are getting confused on is the Trump administration has declared some of these groups as foreign terrorist organizations or designated terrorist organizations. I don't know. I think I don't know that that's a thing. And I think what they're doing is they're saying, look, they're terrorists, as though that then somehow legitimizes it and makes them into military targets. And so I'm wondering if you can kind of even just step back as a matter of constitutional and domestic law and talk about the balance between Congress and the president and, when the president is acting basically only under his Article 2 authority, like how limited it is in terms of the ability to use military force, like what the parameters are there. Because even there, it would be in a defensive capacity with kind of a imminent threat that the country is facing.
Right. So, in a certain sense, just piggybacking on what you had said, yes, after 9/11, Congress passed an authorization for use of military force, an AUMF, that was essentially the equivalent of a declaration of war. That's how it's treated in modern times. And we have no such thing against the drug cartels. There was early on, when the boat strikes started happening, some people even saying, "Oh, well, maybe does the AUMF cover the drug cartels?" It just doesn't. There's no way on this planet it does. The AUMF is about the attack on 9/11 and specific to it. Apparently, the General Counsel of the Department of Defense has briefed members of Congress, and in fact, his first set of arguments to them was what you just described. Oh, look, these were designated FTOs, foreign terrorist organizations, and as designated foreign terrorist organizations, we can use force against them. And there's a bipartisan pushback, which is like, that's not a legal argument. You don't have congressional authority. Congressional authority for the designation of an FTO then comes with things like you can impose massive financial sanctions and seize the assets of the members of that FTO, but there's no end use of force. You would have to have separate congressional authority, the equivalent of a declaration of war, an AUMF, for that purpose. There's no magic in saying that these are FTOs, foreign terrorist organizations. And unfortunately, I think when the Trump administration designated them as foreign terrorist organizations, there should have been much more debate about that because they don't fit the general mold of that. But they are. But let's just assume that they're properly designated as FTOs. So then all he's left with is Article 2 authority as president to do something like wage this kind of a war, or use of military force, I should say. And Marty Lederman in the pages of Just Security has written very persuasively on this, basically saying, and he's the guru on these Article 2 issues, there is no way in which any of the existing Office of Legal Counsel opinions, which themselves are very aggressive in their interpretation of presidential powers, there's no way that they would support the proposition that the president can then go ahead and start using force, especially against, let's put it this way, civilians, like killing civilians. Is there an Article 2 authority for the president to kill any civilians he or she would like around the world? No. And if we're doing the kind of Justice Jackson tripartite test of, is the president at his or her highest power because backed up by Congress, or are we in this kind of gray zone, twilight zone, or with the lowest ebb? Good argument also, we're at the lowest ebb because Congress really has regulated the space of how to deal with drug cartels, and it's through interdiction and law enforcement. They have decidedly opted against military force.
I'm glad that you mentioned civilians because I think that gets to the double tap, because these were, it gets to the idea of non-combatant, right? Like not legitimate military targets. Yeah. I think you make a great point that to call it war crimes is to actually credit a certain underlying framing that doesn't apply here. I think it should be noted that even in the war on terror, the Supreme Court said that the Geneva Convention applied. So in other words, even if they're they keep hitting these walls, right? Like even if you were to accept certain things, you can't get there. So the first strike in itself, I think what you're saying is it's not legitimate based on what we know, that there is no basis for using military force against them. Can you talk about that? And then what happens when there are survivors, and talk about the Geneva Convention and all that whole framework under international law as well.
Sure, thank you, and also thank you in the sense of I do worry, and others worry as well, that when we talk about the double tap strike against the shipwrecked two individuals, it might suggest that the initial strike against all 11 when they were on board the vessel was lawful. And now we're only just talking about those two shipwrecked people, and what's the law on shipwrecked? And it's even curious as to why the latter, the strike and the shipwrecked, has seemed to have seriously just broken through on Congress, broken through in the public mindset and the like. But yes, the first strike on the 11, when it first happened, I think I was one of the first people that said this because I was interviewed by the New York Times. I said, I do not understand how the lawyers could have gotten to this as being legal. It's murder. It's murder under the laws of war. It's murder under U.S. domestic law and law enforcement and international human rights. And the reason it's murder is under just give them the Trump administration all the arguments and the idea that this is a law of armed conflict. The Geneva Conventions apply. These people are civilians. I worked inside the Pentagon. There's no way you can get to a place in which those 11 people are not civilians. And especially, I just want to put a finer point on this for those who are like closely following or haven't followed some of it, especially given the new information that we have from a lot of media reports that the Office of Legal Counsel opinion is now apparently also based on this idea that I had advocated actually against the ISIS operations when I was inside the government and then outside the government, wrote a law review article in it, that they're engaged, that the part of the legal justification for hitting the boats is because the boats are a source of finance for the drug cartels. And it's that war-sustaining finance that would be the legal justification. I wrote, I think, the law review article that justified war-sustaining targeting. One of the limiting principles of war-sustaining targeting is even if you assume that argument, like that the drugs are like a source of finance, the people carrying them are not combatants. They are not fighters. And we now know from a lot of reporting and Associated Press in particular, they're just mules mainly. They're not even members of the cartels, at least in large part, or we don't know of any ones that are. That's also why Hegseth refers to them as affiliated with or associated with the drug cartels. But those 11 people are the equivalent of the oil tanker driver of the truck in ISIS. So when the truck driver drives ISIS's oil to the market to get them revenue. So I was one of the people who had an aggressive reading of, or a favorable reading of, that the truck is targetable. The driver is not targetable. The driver is a civilian. So there's 11 people are civilians. The U.S. military, and that's why Marty Lederman wrote the very first piece that also said something just has happened here and is happening that is a sea change from anything that we can think of in modern military history, which is the United States policy is to kill civilians. Like that is what happens with that 11 people on the boat, and it's what's happened with the subsequent 20 plus boat strikes. To the shipwrecked piece, now on that one, I do think I should just put it this way, and I think this may be why the shipwrecked incident is a breakthrough incident. That, what I just described is complicated. Like if you put a heading on it, it's complicated. I have to walk through a lot of legal arguments. I need to point to the sources.
And people's eyes glaze over and they don't really follow because, Yeah,
the shipwrecked one is not complicated. It's clearly illegal. It dates all the way back to the Lieber Code. There's a major decision in World War I, a criminal war crimes tribunal decision. There's a major decision in World War II in which German soldiers fired on shipwrecked individuals after blasting their boat out of the water. And in all those tribunal decisions, war crimes trials, the court says everybody knows this is clearly illegal and against the fundamental dictates of maritime warfare. You cannot target people once they're shipwrecked and clinging to the vestiges of the blown up vessel. And all through the chain of command, they should have known that. That's also why I'm very inquisitive about Admiral Bradley. I mean, he's a Navy person. He should have known that. And the other way to just put a punctuation mark on it, the Department of Defense's Law of War Manual has a provision on the duty to refuse illegal orders. The second sentence after it says there is such a duty is, for example, an order to fire on shipwrecked people would be clearly illegal. Like that's their paradigmatic canonical example because it's just so absolutely clear. And that's why it's in some sense monstrous, because this really is similar to what the Germans were doing in World War I, World War II, and the Japanese Navy.
So Ryan, I mean, this is, as you point out, something that's so outside the norm of what whatever be done. So obviously indefensible. But I think one thing we've learned over the course of many years now, because this is our second Trump administration, is defending the indefensible is just another day in the week for the Trump administration. So what I think is remarkable is it's challenging to come up with a justification for this particular action. And that's maybe what sets this double tap. I mean, I don't like the word double tap because to me, it sounds like something you do with your mouse, not the murder of people. Okay. But this second killing, this murder of these two individuals or multiple individuals in the second strike, how what arguments do we expect the Trump administration to trot out, or do we take Trump's comments, kind of throwing Hegseth under the bus, to mean that there's going to be someone, whether it's Hegseth or Bradley or someone else, who's going to become the scapegoat for an indefensible action?
Yeah. So I do anticipate one set of arguments. So that the arguments would be, nobody's going to defend targeting the two individuals. Nobody's going to defend that. They just can't. They won't defend it in congressional investigations. They're not going to defend it otherwise. One piece is that I think will be argued is Hegseth didn't state kill all the survivors. That his order was not that explicit, and that's not what he said. That might be one way in which they go. And I've thought about that in terms of other precedents that we have. There was a case that came out of Iraq in which Colonel Michael Steele had allegedly told his subordinates, kill all military-age males. And then they murdered some people. His subordinates are court-martialed. A couple of them plead guilty. He is only reprimanded. And he's reprimanded in part because it's like, no, he didn't actually say that exactly, but because he is in command, as is Hegseth in command, he is responsible for setting this all in motion. So even if that was an ambiguous order, the fact that it set it all in motion, the fact that Admiral Bradley would have interpreted that as his instruction is on Hegseth. So meaning that Hegseth, even in that most favorable light, is not directly responsible for having committed the crime. He would still, you would think, in a normal world, be subject to such a reprimand as what happened to Steele. And the reprimand for Steele was in order to kill his career. Like he was then basically, his career was over. He was otherwise going to potentially be a general. So you would think you relieve the Secretary of Defense from his command if that's what's happened under his watch. So I think that's one part of it. Now, I should mention, though, that I thought it was very significant that the Wall Street Journal in the last 24 hours has corroborated part of the Washington Post reporting, but even more specifically said that according to their DoD source, Hegseth was the target engagement authority. So he might be out of luck if that's the case, because that means that he really was in the loop of deciding on this very particular target on September 2nd and how to strike it. And that certainly would mean that closes off that kind of excuse or defense. That's one piece. The second piece is people are trying to wrap their heads around, well, what if the shipwrecked two people were not the actual target? And what Admiral Bradley was trying to do was eliminate fully the vessel, which had already been blown up, so it's a lot. Think of that like the wood that's left behind and the drugs that were maybe not destroyed in the first explosion. But even so, that becomes more of it's complicated, though I would then just say, I do not know of the U.S. military ever taking a strike for something like that amount of, like, whatever you want to call it, military contraband. I'll just assume that drugs are military contraband of some sort, and kill two people knowingly. Then there would be a proportionality analysis, and the only way you would get to the idea that that's proportional is if those people are completely dehumanized and treated as lawful targets, essentially. So we're kind of like back to square one, and no, they're not.
Yeah, I think this gets back to the law of armed conflict, that proportionality is one of the imperatives when you use military force. And that involves that you have to minimize civilian casualties. I mean, you have a duty to. So in other words, they would have had to take into account that these two people were like hanging on to the boat. And at that point, I mean, again, I just keep going back to the 9/11 context, even with drone strikes with, under the 2001 AUMF that, George W., Obama, all of them did, it was authorized when capture was infeasible. Right? Like, and at that point, where these people, the operation is disabled, it's neutralized. It seems to me that even if you're concerned with that there's still contraband, that, whatever, there is a kind of less lethal way to address that, right? Which I don't know. I think it gets back to the square one, as you said, but I think there's also this argument that it's just completely unnecessary at that point to actually use the level of force that is used.
Yes, and especially if recalling that Secretary Rubio said of that September 2nd strike that they could have interdicted the boat, but they decided not to, and that the president decided not to. So it sounds like they also had, full control over that space in that sense as well, so, which makes it even more egregious. Oh, I'll mention one other piece that people might not realize. The New York Times several weeks ago had also reported on the September 2nd strike that particular vessel in question had turned around before it was even struck the first time. So it's like the lack of necessity on top of lack of necessity. And then once again, I just think it's really important to say, and that's all under the laws of war. The real legal framework, the true one is, it was law enforcement. It should have been law enforcement. Yeah. This is not an armed conflict. And you do not kill two people in order to get rid of the drugs. Like who that's inconceivable. It's an extrajudicial killing. And just to reinvoke Secretary Rubio's name, when he was senator, he was very strong on calling out the head of the Philippines, President Duterte, for extrajudicial killings of killing drug smugglers, because that's what it is.
So, when we talked at the very beginning of the show, the question that we asked, which is truly complicated, is sort of whether the Trump administration can be held accountable for this. And I do want to turn to that, because I feel like, look, one thing I think we've established through this conversation, it's really not that complicated that this was just complete abuse of power. Yeah, illegal act, right?
Yeah.
But I think, particularly given the Supreme Court's immunity ruling, giving immunity to the president, and those following his orders, and I just heard you a moment ago kind of noting that the statement is that the president himself, Trump, gave these orders. Does this mean that there's a complete blank, free pass here for those who are following Trump's orders?
So yeah, it's a complicated set. So based on the Supreme Court ruling, I do think that this was somewhat the hypothetical that was treated, I think, as too imaginative, that the president could order SEAL Team 6 to kill his perceived political enemies. And so we're kind of pretty close to that hypothetical. But I think because that was the hypothetical, I do think that the Supreme Court ruling is that his order for himself and his own liability very well seems like that's in his absolute immunity, not in the presumptive immunity, which was a middle category that the Supreme Court did leave open. That said, I suppose that maybe the Supreme Court that could in a sense be dicta of a sort, whereby something that is this egregious comes forward and they could say, well, no, not when there's congressional legislation. There's the War Crimes Act that would make this a U.S. domestic crime. You don't have the legal authority to go out and kill civilians. And it's not an interference with presidential prerogatives for that to be criminalized.
So you're saying it's ultra vires, like it's not within the Article 2 authority to begin with, and so therefore it can't be an official act.
Yeah, but I think for them to do that, they would therefore be distinguishing their own precedent. Because right now, the standing precedent is, I think, is in his absolute immunity. Now, that being the case, I do think one of the questions that was always left unanswered by the Supreme Court is, what about subordinates?
Yeah.
And Asha, you've been very good about this idea as well, which is like, wait, if the president has immunity, doesn't it necessarily mean that the people that he or she orders to carry out his or her instructions have to also have the immunity? Otherwise, the Supreme Court ruling doesn't make sense, because the whole point is that the president has to, act with speed and in the interest of U.S. national security and the like. So that said, if we take the Supreme Court's precedence on civil immunity, it would suggest that, yes, the subordinates have immunity, but it's not absolute, it's qualified. And then that qualified immunity, I think all of this breaks through, because what is qualified immunity? Well, if the person knew that these were manifestly illegal orders, it's probably not going to get qualified immunity. And that, in fact, is the test under the Uniform Code of Military Justice. That's the test under international law. That's the test that's in the DoD Law of War Manual. And so if I were one of those people in the chain of command, I'd be very concerned, especially because the U.S. military has made a practice of, I think, getting towards accountability. It's by far not perfect by any stretch. Colonel Steele, who I mentioned from Iraq, I think he got off easy in a certain sense with that reprimand. But there are court martials, and I do think that they would want to get their house in order. But it's complicated as well, because it's very difficult to sort out why Admiral Bradley would have done this. But I should say that's the shipwrecked strike. But I think Renato, what you were asking is actually about the entire military operation, the 20 plus strikes, which seem to be clearly unlawful. And there again, though, I think people would need to be quite worried that they would not have the same kind of level of immunity that the president does.
I think it's worth pointing out, Ryan, that even though it's not necessarily accountability, one thing Congress could do is actually, in some way, whether it's a joint resolution or something, basically formally object to the use of this. Because I think that then, at least from a legal perspective, makes it very clear that he is operating, against the will of Congress. And that puts him in a more precarious footing just whenever, if there is legal accountability or does come before the court, I think that could matter. So I'm throwing this out there because I think people assume that the president is commander in chief and he can just go around doing whatever he wants. And there is a role for Congress here to assert its own war powers.
Absolutely. And there have been bipartisan votes that have come pretty close to a majority on the Senate side on that particular issue. And this, I think, would only fuel that more so, because maybe Congress just says this is all becoming just way too impalatable. I just want to mention, though, one other piece, which is I do think the proper way of looking at the ongoing military operations in the Caribbean and the East Pacific in terms of the lethal boat strikes is that they are congressionally prohibited. The reason for that is the War Powers Resolution. So the War Powers Resolution says if the president introduces U.S. forces into hostilities, there's a 60-day clock in which, unless the president gets affirmative authorization from Congress, he or she has to terminate those operations. And we passed the clock in first week of November. The administration has come up with a newfangled idea, which is, no, these are not actually hostilities, that the United States military forces are not themselves at risk, which is, as members of Congress have said who have read the OLC opinion on the authorization for all the operations, say that it's contradictory. There are many contradictions in their positions. They kind of say what they feel they need to say in any particular issue. But on that one, apparently the OLC opinion says, no, these drug cartels are like states and they are attacking the United States with hostilities and the like. but that's their argument for it. I think the right reading is we are already in the territory of something that is being congressionally prohibited because the War Powers Resolution says it is prohibited unless you find affirmative authority within the first 60 days.
Well, Ryan, thank you so much for breaking this down for us. I know it's a lot. People might need to go back and, I feel like this needs a chart. I might need to do a diagram for kind of how effed up this is. But I appreciate you, breaking this down for us. People should go to Just Security. We'll put some of the pieces in the links that analyze what's happening, so you can kind of go through and parse the legal arguments and why they don't hold water, no pun intended. But thank you so much for sharing your knowledge with us.
Thank you. Thanks so much for the conversation.
So Renato, that was a good discussion, but I did want to highlight, as we're talking about, this administration basically flouting the rule of law, that to kind of go back several chapters, I guess, for this administration, this Trump 2.0, Judge Boasberg is back in action doing a fact-finding inquiry on who actually disobeyed his order to turn those 2 flights around. Wait, was it 2 or 3? I think it was 3, actually. 3 flights that were going to CCOT back in oh my gosh, I feel like I'm losing my mind on what the months are, but over the summer sometime, where those people were sent to CCOT, and the planes were mid-air when Judge Boasberg issued his order, and they were not turned around.
Yeah, and just to be clear, a couple of things. So we say CCOT, that's actually a very horrific place to be. It's not like a luxury hotel. It's a prison in El Salvador that has very harsh conditions, I think is a fair way to put it. And I think Judge Boasberg believes, this is my analysis here, that there was a deliberate attempt to circumvent his order, and that perhaps there was things set in motion to ensure that his order could, that he had no ability to intervene in that circumstance. And what I really see at a 10,000 foot level here, Asha, is Judge Boasberg trying to fight not just for himself, but for the judicial branch of the United States. And he is concerned that when judges are issuing orders, that the executive branch is not following them. And he is determined, he's like the honey badger, he is determined to go after this. And I will note that Judge Boasberg's original plan here was to not just investigate this matter, but actually to have a referral for criminal contempt. And he originally said that if the Trump administration wasn't going to prosecute these officials in its own administration, that he would try to appoint a private attorney to do so. Now, that's something that the Court of Appeals for the DC Circuit, which I believe is a majority Democratic appointed court, disagreed with and reversed that element of it. But the fact-finding inquiry is going forward, and I really think, Asha, if you had the Supreme Court setting a different tone from the top, not only would the Trump administration may not be doing this, but I wouldn't be surprised if Judge Boasberg, there was a full contempt inquiry rather than a fact-finding inquiry. Yes,
and that court decision that you just said about allowing him to continue, well, the court decision saying that he exceeded his authority because it would infringe, it was separation of powers argument, that what he was doing was infringing on the executive branch's foreign affairs authority. That was in August. And actually, this is how like the months are just blending together. The actual initial the order to turn the planes around was in March. So this all kind of happened in the spring. But one of the things that came to light in this most recent fact-finding inquiry is that basically Kristi Noem is like, yeah, I told them they could land.
Yes. And
I told them that they could keep going to El Salvador. Like, she's basically like,
I did it.
And I also saw I don't think this is something that she said in court, but I did see her on TV basically saying a reporter had asked her, so do you not believe that you need to follow court orders? And she said, we follow lawful orders or something to that, like that are not, this is an activist judge. We follow orders that are, based on the law or something like that, which is suggested to me that what this administration is basically saying, and we have seen this in a lot of other contexts, that they are taking it upon themselves to basically pick and choose which court orders they believe that they have to comply with.
Yes. And I will also note that the statement that was filed with the court, with Judge Boasberg, that sort of first brought this to light, that talked about Kristi Noem doing this, had like this very carefully worded passage where it said that she sought the advice of Todd Blanche, Deputy Attorney General, former personal attorney for Donald Trump, and then, as a result of that advice, of course, they're not going to reveal this attorney-client privilege information. As a result of that advice, she decided to go forward, and I think it's sort of setting up a situation where they can kind of come up with whatever legal justification later fits what they think they need to do to kind of try to make this seem palatable on appeal, and kind of give her maximum protection. And really ties into what we talked about in the last segment about, how much immunity do these non-presidents have?
Yeah, and to be clear, the legal advice, the filing from the DOJ states that Deputy Attorney General Todd Blanche and Principal Associate Deputy Attorney General Emil Bovee provided DHS with legal advice regarding the court's order as to flights that had left the United States. There is a whistleblower from the DOJ that has said that when all of this stuff was unfolding, this is the context in which he alleges that Bovee basically said, something to the effect of, we can tell the courts to F off. So, even the legal advice is sketchy because we are talking about people who have, from the get-go, been showing a contempt of, the courts and, feeling like they have leeway to disregard. So, yeah. And I mean, with Todd Blanche, we've seen in other contexts, for example, with Glenn Maxwell, it's sort of like creating these, thin covers, pretexts to basically engage in whatever they want. So, I think we'll keep an eye on that. And right now, Judge Boasberg has ordered the Trump administration to submit declarations by the end of this week from everybody that was involved in the decision not to turn around. And I guess if he does refer somebody like Kristi Noem for a potential contempt prosecution, he's sort of back to the same square one, right? Because the Department of Justice is not going to pursue that. That's
right. And I think that, if they did, of course, you'd have an advice of counsel defense. That's in part the point of this, if it ever got picked up at any point. But the reality is nothing's going to come of it. And Judge Boasberg is trying to do whatever he can to bring this to light, to get the facts to account. He's clearly concerned and upset about this, but he's I'm not going to say he's an army of one here, but he is definitely does not have the support of the United States Supreme Court in this endeavor, or the United States Court of Appeals. And so, this is an example of the Trump administration, quote, getting away with it, unquote. And I think it's worth noting from that perspective.
Well, I guess I would push back a little bit, Renato. That may be true, practically speaking, but I do think that there is value to documenting and getting into the record what happened. Like, I think that people have gotten to a point where it's easy to throw up your hands and say nothing's going to happen to them, so why bother? But I think there is a reason to bother.
I agree.
In all of these processes, even in Trump 1, when the impeachment proceedings happened, even though there was no possibility of removal, there is a value to actually documenting. And I don't know what the whether this is something that could be pursued by a future Justice Department, but I think every actor in our system, including people, judges, should act with the most robust authority they have to go as far as they can. That's my opinion.
I agree with that. So, Asha, before we go, this is going to be our last recording of 2025 because I think both of us are going to be doing a lot in December to travel and enjoy the season.
Yes, I'm actually leaving in an hour and a half to JFK to go to Germany and then to go to Thailand. So, and then where are you going on vacation?
So a little bit later, next Thursday, I'll be flying. So the 11th, I'll be flying out to go. I'm flying to Istanbul via London, and then after spending a couple of days there, my wife and I are doing a river cruise in the Danube, and then we're going to end up and spend a couple days in Vienna. So that'll be a lot of fun.
Amazing. So I guess we will see everybody when we return after the new year.
That's right. So we're looking forward to it. And in the meantime, Merry Christmas, Happy Hanukkah, Happy Kwanzaa to everyone who celebrates the holidays over this season.
Happy holidays.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.